what we have is there's a petition to determine the sufficiency, and we have one side saying it's sufficient, one side saying it's not. I could really start with either side. In my mind, it makes, unless Mr. Eyman wants to pass, I'm inclined to hear from him first because you're the proponent, let's say. And so you don't have, this is an unusual type of proceeding, but I'll just say, you could have 10 minutes to talk, Mr. Smith gets 10 minutes to talk, and then if anyone has something to say at the end, you can say some more. So, Mr. Eyman, the floor is yours.
Thank you very much. Is this distance okay? Okay. Tim Eyman, thank you for this opportunity to bring this up. Never done a recall before. It's not a very common process. I've certainly seen other recalls done over the years, so this is my first one, and so learning experience. I guess we just start with the beginning. There was an initiative 2081 on parents' rights. It had several provisions, most of it just having to do with parents having access to information about their kids while they're at school. The legislature overwhelmingly passed it. I believe it was unanimous in the House, and in the Senate I think a couple of them voted no, but they all voted for it. So not a big threat to the public health and safety for us to be able to have access to what's happening to our kids while at school, but it took effect. There was a lawsuit. The lawsuit was eventually dismissed in King County Superior Court, and so it took effect in January. So the thing I would emphasize again is the legislature did pass it originally, and if they had tremendous concerns about it, they probably wouldn't have passed it. So I think you could take judicial notice of the fact that it did pass overwhelmingly. But this legislative session, they decided to change it, and with a bill. The bill had 27 sections to it. The referendum that I filed only challenges one of them. One of those sections is the one that changes substantially the rights that parents have. So I filed a referendum on it. First day you could file one was the day after the legislative session. I filed it on the first day, April 28th. I submitted a payment. From lawyers I've talked to, they think this is a significant point. I have a receipt for it. It's in Exhibit A of my reply brief, and I paid those dollars, and I entered into a contract that the Secretary of State would process it. The statute is very clear that when they accept the money, they process it. They did process it to a degree. They recognized that it was a referendum. They accepted my money. They processed it. They gave it a referendum number. But they did not forward it to the Attorney General. There's a statute that is explicit, and it doesn't have any exceptions. It just says the Secretary of State shall give a serial number to each initiative referendum bill and forthwith transmit one copy of the measure proposed bearing its serial number to the Attorney General. He didn't do that. Most of the recalls I've seen, it has to do with malfeasance, misfeasance. They stole some money, they did some kinds of things. But violation of oath of office is simply, there's a law in the books that wasn't followed. The Secretary of State took an oath to dutifully and, what's the word? Dutifully, there we go. A violation of oath of office means a neglect or knowing failure by an elected public officer to perform faithfully a duty imposed by law. I just simply continually look at that statute, and it says, and shall forthwith transmit one copy of the measure to the Attorney General. I keep staring at it, and it says you'll do that, and he didn't. In their brief, they talk about, he thinks he has a legal justification that it's okay. I'm just thinking as a layman, I didn't intend to speed at 80 miles an hour in a 55 zone, but whether you intended to or not, you weren't following the law. Here, he didn't follow that law. I can't, again, get my mind wrapped around it. If they want to rewrite the statute, have the legislature change it so that it says from now on, unless the Secretary doesn't want to, or unless the Secretary feels justified in not
So
doing
if
it.
you can't do a referendum, at what point does the process stop? Why does it make sense if this is invalid under state law because of the emergency clause, which again is not the subject of today's proceedings?
Right.
At what point does the train stop?
And I think I understand the question, but can you clarify what you mean?
Yeah. So
Sorry.
This referendum that you wanted
Yes.
can't happen under state law.
Okay.
Under existing state law. So at what point does the referendum process stop, given that it's an invalid referendum? Is it you're not allowed to file it? Is it he can't then give it a number and transmit it to the AGO? Does the AGO then stop and not do their part? Are you not allowed to collect signatures? Is this not allowed to go on the ballot then later? Does the Secretary of State stop it? Does it go to the election and then actually we have to have a lawsuit? At what point, given that the emergency clause prevents the referendum process, does the referendum process stop? Or is it proper for it simply to never start? So where, given that this is the law, do we stop this process?
I guess I take issue with the law.
Okay, so then why are we here on a mandamus action
yes.
instead of this?
Mandamus action is not before you. It has to do with a recall. But the point you make is that in 2002 there was a referendum. The legislature passed a law, happened to have an emergency clause attached to it, as it turns out, and there was a referendum, Referendum 53. The Secretary of State forwarded it to the Attorney General, fulfilled his ministerial duty, sent it on. The Attorney General prepared a ballot title for it. The proponents of it started collecting signatures. Opponents of what was happening went to court and asked the court, stop this. It strikes me that that's the proper process, is that they fulfill their ministerial duties, and if somebody has a problem with it, and it could include the Secretary of State, it could include the Attorney General, any of them can walk into a court and say, we do not believe this referendum is valid. That's not what's happening here. What's happening instead is that you have ministerial duties that are being set aside and not fulfilled because the Secretary of State is essentially substituting or stepping in and fulfilling a judicial role. And one of the things I did find in some of the previous cases is that the court evaluates emergency clauses on a case-by-case basis, and at this point, when that came down, the court had upheld emergency clauses in 11 cases and invalidated them in 7. So sometimes the court says it's a valid emergency, sometimes they don't. Here, you're never going to be able to have a chance for the emergency clause to even be evaluated because there's no opportunity for you to be able to even move forward with your measure because they're not fulfilling that ministerial duty, which is unambiguous. It says you will forward it to the Attorney General. So short answer to your question is, when do you stop? It's when a court makes a determination, not when the legislature and the executive branch, the Secretary of State, decides that it's not worthy of continuation.
But couldn't we also have a situation where this Secretary of State does what happened here and you say, wait, why aren't you transmitting my stuff? Then you seek a mandamus action and say, you aren't doing this ministerial action. So why is it incumbent upon, at what point do we decide one person has to do it rather than another? Why can't we just stop it from the get-go? So why didn't you file a mandamus action?
I did have, and in the process, 40 days have been chewed up of the 90 days. We're waiting for the Supreme Court to rule on this, but the reason I'm bringing a recall is I simply read it, and it says, to perform faithfully a duty imposed by law. Whether mandamus or is agreed to or disagreed to by the court, I keep staring at a statute that says you're going to forward this thing to the Attorney General, and he didn't do that. I don't think there's any malice involved. I don't think he's just a bad guy. He's probably not the worst Democrat we have down there. It's just that there's a law that says he's got to forward it, and he didn't. And when I see a law that they're not following, it's, as a regular taxpayer, I get kind of frustrated saying to myself, well, wait a minute here. The law says you got to do it, and he says I got a legal justification for not doing it. It strikes me that he should just perform his ministerial duty, forward it on. The Attorney General, just like he did with the ballot synopsis, just draft it. Don't take a judgment call on it. And if somebody has a problem with it, go to court. Because One thing I did learn throughout this stuff is that it's a judicial decision. It's not an administrative decision on what's an emergency and what's not. It's always the courts that have to make that decision, and they do so on a case-by-case basis. Maybe this one would be evaluated as a valid one. Maybe it'd be found to it'd be an invalid one. But because the administrative process is stopping it from even proceeding, there isn't that same guaranteed under the Constitution 90 days to collect signatures. And so I almost call it administrative inertia. Unless acted upon by an outside force, the Secretary of State's going to continue to do this. And there were 46 bills this legislative session that had emergency clauses attached to them. If I had paid $156 for every one of them, they would have blocked every one of them. They wouldn't afford a single one of them on, because this is our policy. Our policy is to not forward it. I challenge the fact that how can you have a policy that directly contradicts a duty that is imposed by law when the law says you've got to forward it on?
Okay, so we'll stop over the 10 minutes, but I'm going to come back.
Oh, did I go over? I'm
Yeah.
sorry.
I didn't warn you. So,
I'm answering your questions though, so.
absolutely.
Loophole.
I'm going to give you more time.
Appreciate it.
So what happened with the Supreme Court on June 4th? Do we know yet?
May I come up?
Yeah, you can, wherever you want to go.
Thank you. As an appellate attorney, the podium is my natural habitat. So on June 4th, the court considered the matter at an en banc conference. We do not have any communication from the court at this time. So
Good
we don't
times.
know what has happened with respect to the mandamus petition.
Okay, and, and it's not necessarily directly relevant, I mean, it's relevant, but it's not dispositive on these issues, I presume you would say. We don't have to wait for the Supreme Court, given the statutory timelines for the recall petition.
That is correct, Your Honor. And for the court's information, the position that we took with respect to the mandamus petition was that mandamus wasn't even appropriate because this should be an APA action. And in an APA action, you can seek a temporary restraining order. You can seek a preliminary injunction. So there are options, if somebody believes an emergency clause is invalid, to challenge that and do so promptly.
Okay, so there's a flip side. I asked Mr. Eyman a bunch of questions, so I'm going to have some questions for you. So why doesn't the Secretary of State just do the thing like has happened in the past and let someone else stop it? Well, why the statute doesn't provide for this off-ramp. There's basically is a judgment call here saying you can't do this, so I'm not going to do this. Why not just do the thing and let someone else challenge it later?
So this goes to the legal justification, Your Honor. And that legal justification
Can you
is...
slow down a little bit, please?
I said my goal for today was to not be asked to slow down. So this goes to the legal justification. And the legal justification is that emergency clause and what the Washington Constitution compels as a result of that. And of course, the Washington Constitution takes precedence even over statutes. So what the Washington Constitution says is that when there is an emergency, a bill is not subject to referendum. Here, we have a law passed by the legislature, approved by the governor, that says there is an emergency. That is the law. That is presumptively valid. And therefore, our state constitution tells us there cannot be a referendum. So that's why the Secretary of State's office rejected the proposed constitutional amendment. And that's consistent with over 100 years of practice.
100 years of practice or 100 years of... So has the Secretary of State always rejected referendums with emergency clauses in this way?
I can't say always. I am not aware of a circumstance where the Secretary of State has accepted it. Mr. Eyman has identified one. That wasn't in his briefing, so I wasn't able to verify that. But what I can show, and we showed in the brief, is that going back to 1921, multiple Secretaries of State have taken this same position, where the legislature passed a bill with an emergency clause, somebody filed a proposed referendum petition, and the Secretary of State refused to file it because it was subject to the emergency clause. Now, what's happened in those cases is the proponent of the referendum has then brought a legal action, such as a mandamus petition or other legal action, taken it to court, and the court assesses the validity of the emergency clause itself. And those cases have gone both ways. Courts have found some emergency clauses valid, some emergency clauses invalid. But no court has ever said that the Secretary of State should have filed it in the first instance. where they direct the Secretary of
Has
State.
that question ever been raised in those prior cases?
It was raised in the Washington State Farm Bureau Federation case, Your Honor. And this is something that really struck me as I was reviewing materials for this hearing, which is Mr. Eyman's recall petition has a section that lays out the legal framework for a referendum process, and in terms of what the Secretary of State should do. And as I was rereading it, I noticed that is cut and pasted from a dissent by Justice Jim Johnson. There are some words that are changed here and there are some paragraphs that are deleted, but it is cut and pasted from a dissent by Justice Jim Johnson. A dissent does not tell us what the law is. In fact, in this context, a dissent tells us what the law is not, because the majority did not adopt the position taken by Justice Jim Johnson that the Secretary of State should have filed the referendum petition. The majority instead reviewed whether the emergency clause was valid, concluded that it was valid, and then denied mandamus. But under Mr. Eyman's theory, the majority should have granted the mandamus petition and directed the Secretary of State to file it. So the Washington Supreme Court has implicitly agreed that the Secretary of State does not have a legal duty.
But it's implicit, not explicit. I mean, because that was attacking the emergency clause in that case.
Well, but they did make a specific argument that the Secretary of State had this duty, and the majority did not adopt it. The dissent took the majority to task very vociferously, and nonetheless, the majority didn't adopt it. But let me take one step back here, because there can be a legal justification, even if a court later concludes that the elected officer was wrong on the law. And that's in the recall of Inslee case from 2023. One of the charges for the recall there was that the governor had improperly used his veto authority. The Washington Supreme Court, by the time of that recall case, had already agreed with that, had already agreed that the governor had improperly used his veto authority. Nonetheless, the court said that there was a legal justification that prevented the recall from going forward. And they pointed to the fact that there was a dissent. There was a reasonable, good faith difference of opinion as to what the law required, and so the recall could not go forward. So even if we were wrong on the law about the Secretary's duty to file a proposed referendum petition on a bill that contains an emergency clause, this recall petition is legally insufficient and cannot move forward.
Okay. Anything else you want to say?
I just briefly add on the factual sufficiency piece. We addressed the fact that when somebody is basing a recall on an alleged violation of law, they have to have a basis showing that the elected official intended to violate the law. In his reply brief, Mr. Eyman argues that there should be no intent requirement. He says there's no intent requirement in the statute, but it's black letter law under multiple recall cases by the Washington Supreme Court that you do have to show an intention to violate the law. There is nothing in the record here that indicates an intention to violate the law. But there's also nothing in the record here that shows that Secretary Hobbs was personally involved in the decision that is the basis for the recall petition. That's required under In re recall of Morissette, In re recall of Durkin, In re recall of Inslee, the 2023. So in conclusion, to move forward, Mr. Eyman has to show that the recall petition is legally sufficient and factually sufficient, but it's neither. This court should dismiss the recall petition and prevent the recall petition from moving forward.
Okay, thank you.
Thank you.
Mr. Eyman? Rebuttal.
I appreciate that. So much to unpack, so I'm going to do my best. Implicitly, I really was struck by that. Implicitly, I keep staring at the statute that says forward it on, and it's black letter law, I guess, based on that. When he says law, I think he's referring to case law, how it's been interpreted. I'm staring at a law that is not subject to interpretation. It's 100% clear, you shall forward it. Your opening question, what's the harm in you just forwarding it on and letting the people that are opposed to what this thing is about challenge the referendum after the fact? I thought the Philadelphia 2 case was very much on point. In Philadelphia 2 in 1996, the Secretary of State did forward a ballot measure on to the Attorney General, and the Attorney General chose not to give it a ballot title because the Attorney General made a legal determination. She didn't think that it was a valid initiative. they went through all the processes that Mr. Carl said that we could have done, go to lower court and done all those things. That's what they did, and the time clock ran out, and so they never got to the point where they could even do the thing. But what made it, even though it was moot, even though it was moot, the Supreme Court said, this is likely to come up again in the future. The Attorney General should have given it a ballot title. It seems analogous to this situation where you should be able to look at a statute that says that he has to forward it on, and I literally cannot get my mind wrapped around what is the legal justification for him not following a law that says that he should do it. And the final point I would make, and I always say this is my final point, I come up with 8 more, but it is a judicial question. It is up to the judiciary to make this decision. Here, this is the Secretary of State, a member of the executive branch, making a determination over a legislative decision. It is not the job of the state executive to make such decisions. It is the judiciary. Marbury versus Madison. It's our job to decide what the law is. It is not up to them. They're taking at face value what the legislature's done. I absolutely agree. They have strong deferral. The judicial system has given enormous deference to the legislature on what's an emergency. But not every time. They don't do it all the time. The fact that it's not every time, it's on a case-by-case basis, and at this point they had 11 cases where it was upheld, but 7, and this is like in 1963, 7 occasions where they invalidated it. Here you're chewing up 40 of the 90 days when it's possible that this is an invalid emergency. And it strikes me that you should allow the process to go forward and allow the signature collection process and let the judiciary make these kinds of determinations. I do have one last point, and it's a serious point, but it does sound funny. Jim Johnson is a radically better lawyer than I am, so I completely felt comfortable copying his arguments because I thought they were very, very persuasive. And so, yeah, he's right. I took some words out of it, but I'm told in the legal community that
it's not plagiarism.
It's not plagiarism. Thank you very much. So I think it's a valid point that I think his arguments were very persuasive, and it does strike me that, and I got to get into this, is it was so twisted. We have a ministerial duty to not forward it on. My argument is they have a ministerial duty to forward it, and they twisted it around and said, our ministerial duty is to not forward it on. I guess ultimately it's up to you, Your Honor, but it strikes me that unless this court allows this to go forward or that mandamus is successful, they're going to keep doing this. And it just strikes me as, well, get rid of the law then, and don't take my money, and don't continue to, why accept the money if you're not going to accept the referendum? They gave it a number. They recognized it was a valid referendum, but they're not processing it. And, I don't want my money back. I just want them to forward the thing on the way the law requires them to. I appreciate your consideration and your time.
Did your client refund Mr. Eyman when he rejected Mr. Eyman's referendum?
That's not in the record, Your Honor. That has been the practice in previous circumstances, so that hasn't been raised. I'm happy to look into it.
Just wondering.
I don't want the money.
Okay.
I don't want the money. But anyway, it's a point I was hoping to raise. Thank you.
Thank you. Court's ready to rule at this time. So, this interesting and important issues. First, there's a lot of things that were referenced here that are not for this court to decide today and are not properly before this court. I'm kind of going to work backwards here. The question of whether or not Mr. Eyman or the public can start collecting signatures for this referendum is not before me today. The validity of the emergency clause is not before me today. So what we had here was Mr. Eyman properly, accurately gave a summary to the posture, but the legislature passed the law this session. The validity, the wisdom, the constitutionality of that law is not before me today. That may be challenged in other venues and other cases. That has nothing to do with this case yet today. as part of that law, the legislature included an emergency clause, which in essence does various things. But it makes it effective immediately, and also says that normally you have to wait until some amount of time after the session and the signature for a law to be valid, unless it's an emergency, then it's immediate. But the other thing that's more important here is that it also means that you can't file a referendum. The question then, there's been litigation at different times, well, is that emergency clause truly valid? Is this really an emergency? That's not before me today. There's a pending case that apparently the Supreme Court had some decision-making meeting about a couple days ago, but hasn't issued their decision. That's separate from this case. The issue of whether or not the emergency clause was valid / whether or not as a result, Secretary of State should be obligated to do what's at issue here is actually not part of this case. That's a separate case. When you want to have a statewide official do something, you file a writ of mandamus with the Supreme Court because that's the statewide court. And that's pending, and you all could be walking out of here with an email in your inboxes. I don't know, but it doesn't really matter for me here today, except for me to make it really clear this case and I have nothing to do with that. This case instead is about a recall petition. The recall petition says, well, actually, because Secretary of State determined that they weren't going to be doing what the statute prescribes for giving numbers and passing on referendums to the AGO, that rises to the level that justifies a recall petition to remove the Secretary of State from office. So let's assume for the moment that I agree with Mr. Eyman on everything that he's saying. All that happens now is that he's allowed to collect signatures to potentially put on the ballot the removal of the Secretary of State from office for this issue. The courts serve a gatekeeping function in terms of determining whether or not to get to that next step. Anyone can file a recall petition if you file the requisite paperwork and provide the fee. Then comes to the court to say, is this the type of thing that this state has recall petitions about? And there's two different requirements here. A recall petition must be both legally and factually sufficient. So you need both. If you are legally but not factually sufficient, you don't pass go. If you're factually but not legally sufficient, you don't pass go. You need both to approve and allow to move forward a recall matter. So we'll start with legal sufficiency here. Legal sufficiency means the charge must define substantial conduct clearly amounting to misfeasance, malfeasance, or a violation of the oath of office. Legal sufficiency is not satisfied when there is a legal justification for the challenged official's conduct. That's from a Supreme Court case from 2003. What is a legal justification? That's really what we focused here on. A legal justification exists where the official acted on a good faith understanding of the law, even if a court later concludes that the action was not lawful. So I think that's the critical point here. The question is whether or not the action was so out of line with the law that there was not a good faith understanding or a good faith basis for acting in the way that is alleged to have occurred. So what we have here is a statute about giving a number to a referendum and sending it over to the Attorney General's office. The statute, the statutory scheme, is silent as to these issues. It does not say, even if there's an emergency clause, you need to do this. It also doesn't say, however, if there's an emergency clause, don't do this. The law does not lay out an explicit path for what you do in these circumstances. Mr. Eyman's argument makes a lot of sense to this court in terms of, well, if it doesn't say don't do it, do it, and let it get sorted out later. What also makes sense to this court, however, is the long-standing practice, including the Supreme Court's implicit green lighting of this type of practice of not doing this, not giving a number, not passing it on to the AGO, and allowing this to be sorted out through a mandamus action. And so what we have in essence is a statutory scheme that is silent as to this issue, which could be a point in Mr. Eyman's favor, because if it's silent, just do the thing. On the other hand, we have long-standing practice and still silence as to what to do in these issues, where what the Secretary of State has done here has occurred repeatedly in the past. And so what I am going to rule is that both paths are reasonable constructions. There isn't a ministerial duty to not pass it on. There also isn't a ministerial duty to pass it on. Because the statutory scheme and the lay of the legal landscape is ambiguous as to what the duty is here. One could even construe this as a circumstance where perhaps due to the legal ambiguity, the Secretary of State has discretion to do as the Secretary of State deems appropriate. Because I viewed both sides' legal arguments to be reasonable as to what the Secretary of State is, both sides, I believe, have good faith arguments for their proposed course of action. But if both sides have good faith, it means the Secretary of State had good faith in his understanding of the legal requirements that applied in this case. As a result, I do find that there was legal justification for the Secretary of State's actions here. As a result of that, I find that the recall petition fails to satisfy the legal sufficiency prong in this case. Perhaps this is a circumstance where the law could be cleaned up to make this clear so we don't have to do this again in the future perhaps, but as of the current time, because of that legal ambiguity in this court's minds, both sides' articulation of what they think the law means is reasonable and is in good faith. But that also means the Secretary of State was acting in good faith when he did, or his office did, what his office did. I say his office because there's also a factual sufficiency part that I'm not going to reach because I don't need to. Because if we fail on one of the two prongs, that's enough. We don't advance the recall petition. So I'm finding that this recall petition is legally insufficient and shall not proceed past this hearing here today. Subject to a right to appeal, of course, but it is not going to be authorized for the gathering of signatures, and I also don't need to look at the synopsis to see if that needs to be altered at all. And so, do the parties require any clarification, Mr. Smith?
No, Your Honor.
Mr. Eyman?
Since it is subject to appeal, I would request that you consider the factual side of the equation as well. Didn't sound like I was going to win on it, but nonetheless, I was wondering if you had come to a conclusion on that.
I have not. Judicial economy and such, and data also, to be frank, subject to appeal, appellate courts are not going to provide me any deference. They're going to look at this record, and they can look at that themselves as well. And so I'm stopping at step one because I don't need to get to step two. If the appellate courts need to get to step two, they'll get to step two just fine. So if you all have a form of order perhaps you can confer about and pass up, that would also allow the clock to start ticking for any appeals so that things can be put to bed on this chapter soon. And so, anything else, Mr. Smith?
Your Honor, we had submitted a proposed order. Did the court receive that?
I received it, but I don't have a copy of it with me. Do you happen to have a copy with you?
I have a 3-hole punched copy.
I don't care about the holes and the punches. And so if you want to look at that with Mr. Eyman, so we can look as to form, and you can hand that up before you leave the courthouse today, that would be great. Thank you.
And again, I don't want the money back, but I will confer with him on that topic after the appeal. Thank you.
So, thank you. Okay, so while you all shuffle around, I'm going to have the ecology case next. I'm going to step off the bench just so we can have a little breather, and I'll hear that case next. You can come up into the well, the courtroom while I'm out. Thank you. Thank you.
All right. Recess.